Hi, this is Kurt Barone, and welcome to another edition of Fire Law Roundup.
Here we have I think I'd almost say that your title is a little misleading, but so the title, Wisconsin IAFF local president fired. He's not fired as president, right? He's fired as a firefighter over a social media post. And clearly, one would argue that he's speaking on a matter of public concern, which is saying there aren't enough ambulances in place on a certain day, certain time, and that he gets terminated for making inappropriate comments. And I'm really shocked if that's all he was making comments about, that, hey, we don't have enough ambulances. They must have been gunning. If that's true, they must have been gunning for this guy, because that's a pretty innocuous comment that anyone would have thick skin on, and more so would say, you know what, look, we'll determine, as chief or city, we'll determine how many ambulances are enough. You don't. And it's totally reasonable for the IAFF to make a comment of we're understaffed, right? We're not serving the community.
Right.
I would argue that is a matter of public concern. Obviously, it also relates to the job, right? Hire more people, etc. So it's got a mix. But man, to fire him over this,
well,
the
Pickering case, a lot of times we tend to think about the Pickering balancing test when it comes to the First Amendment. But there's another part of Pickering that talks about, can someone be disciplined for stating something that's false? And the Supreme Court said no, that if you're going to discipline somebody just because what they said is wrong, that could violate their First Amendment rights, assuming what they said is entitled to First Amendment protection, that it's a matter of public concern set as a private citizen, and the balancing test, the balancing part of it. But in this particular case, I'm thinking that even if he's wrong, they have to prove that it was maliciously false. It's the New York Times standard. Okay, you've got to show that you either knew what you were saying was false, or you were reckless with regard to the truth or falsity. Just being wrong isn't enough to punish someone when we're dealing with something that's a matter of public concern. It's got to be maliciously false.
Yeah, and I was looking this at, if you want to look at it that way, if it was made prospectively that I'm going to try to induce fear in the public because you are not going to put a certain number of ambulances on, et cetera. In the past, it's hard to make an argument like you panic the public, or, you created dissension in the fire department. I don't know. I just, there's got to be more. I can't imagine you just getting terminated for that comment or these series of comments.
Well, in prepping for this, I sent you a link to an article just about what's going on in Wisconsin. And I had no idea Wisconsin at one time had very robust collective bargaining laws for public employees. And then there was some sort of looked like a revolution, anti-employee revolution in 2011 that kind of set them back a little bit. And so it seems like collective bargaining is unsettled, but at least based on what I could gather in the time leading up to this, it does seem like employees have a right to engage in concerted activities. Now, those of you who've been through my social media class are going to go, oh, here he goes on concerted activities. But we have two sets of rights. Most firefighters, particularly in collective bargaining jurisdictions, we certainly have First Amendment rights. We also have this other set of rights, which is concerted activity rights, which when you're talking about work and you're talking about collective bargaining type matters, and particularly here, they're talking about contracting out things that used to be done by members of the local. You're talking about something that could fit under that concerted activities type of protection beyond just the First Amendment. And it just opens Pandora's box to a bunch of other defenses, or not even defenses, claims that the union president would have, in terms of, so sounds like he doesn't necessarily need any more, but that concerted activity protection may also come into play, in terms of where he goes with this next.
Yeah, I guess I'm just a little, there's got to be more. Nobody, I mean, maybe, but normally a bigger government would not take this route to punish somebody for making these comments. And more people have thick skin, unless this was just a final straw with this guy. They didn't care, let the chips fall where they may. But if my advice is true or not, if I always say, listen, do you want to just suck up a day of bad press, or do you want to be in a court for the next 2 years on a very difficult topic? Judges don't understand Pickering, and judges, right? And all the law, we've discussed a bunch of good laws that we think are helpful, or cases that are really helpful defining it, but they just evidence the confusion that exists, that people really don't understand the rules. Pickering's so vague anyway, and as it's applied.
Yeah.
But to just don't terminate somebody for something they say unless there's a real issue with it. I tell people, just suck it up, Buttercup.
You don't like somebody, or you feel like this person's a thorn in my side, and now you're giving me the chance to take them out. And, sometimes they just can't resist, taking that option. So.
And if unions are going to go nuts. Unions are going to say, look, you're going to force us. If you don't, to the court, they're going to say, if you don't make this conduct, prohibit this conduct by imposing a big judgment against, this employer, then unions everywhere are going to be subject to, the termination of their presidents for sticking. I could see all the political ramifications, and I wouldn't want to be, the employer in this, if true. So.
Right.